Your mom who still asked you if you and Thingy are serious. Thingy being Don, your husband. Yes, she still makes you have those annoying relationship chats. But good news, she's family, which means together you can save. PPS Investments Family Network. The more you and your family invest together, the more everyone saves. So, start building your intergenerational wealth today. Contact your accredited PPS advisor or visit pps.co.za. PPS Investments Pty Limited is an authorized licensed financial services provider.
It's 5 minutes past 11 and I'm Sizwe Mpofu Walsh. And we are going to turn our attention to the question of unfair dismissal as we go to our World of Work segment. Now, just in the news, there's a lot of debate about unfair dismissal when it comes to CEOs and in major companies. But it's also a question that just affects everyday people, especially in the context of the unemployment that we face in our country today. And so we wanted to try and think through this question of unfair dismissal, both for employees who maybe think they've been on the receiving end of unfair practice, and also for employers to make sure that they are following the law when the questions of misconduct do arise. And to help us think through these issues, we've got Tertius Wessels, who's legal director at Strata-G. That's Strata-G. And Tertius, thanks so much for joining us to think this through.
Thank you, Sizwe, and thank you for having me.
Yeah, it's great to be with you. And first, let's try and get our heads around this concept. Just what exactly is unfair dismissal, and what does the law say about this?
All right. I think the first starting point is to realize that in terms of our Labour Relations Act, every employee has the right not to be unfairly dismissed. However, that doesn't mean that employees cannot be dismissed by their employers from time to time.
Sure.
And the law specifically recognizes 3 grounds for dismissal. It's either where it's related to the misconduct of an employee, the capacity of an employee, or based on the operational requirements of the business.
I see.
Now, operational requirements is what we generally know as retrenchments.
Right. We actually discussed that last week, so it's a nice link.
Yeah. And when we talk about capacity, we talk about whether or not somebody is still suitable for the particular position, because
Sure.
employees might develop an illness or sustain an injury that's of such a nature that they can no longer continue working.
Sure.
And the most common form of or ground for dismissal is obviously that of misconduct. And that's normally where an employee has transgressed a particular rule or regulation or policy within the business, and for that reason gets terminated.
Right.
Now, a dismissal will not be unfair as long as it's for either one of those grounds and it's effected in accordance with a fair process. So we normally talk about the substantive fairness of a dismissal and the procedural fairness. Substantive, did you have a valid reason for the dismissal?
Okay.
And procedure, did you follow the correct process?
Right. So we've got operational reasons. That's the kind of retrenchment angle. We've got maybe your capacity has changed, or you just simply don't have the right capacity for the job, and also misconduct if you've actually done something wrong.
That's correct.
And even in those areas, both substantively there has to be a case, but then also you have to follow the right process even when there is a substantive case.
Correct. And because you're dealing with 3 different grounds for dismissal, it's important to understand that there's a different process that employers are required to follow when dealing with a particular ground of dismissal.
Talk us through the different grounds and the processes for each.
All right. So if we look at a misconduct, that's when we normally talk about a disciplinary hearing that needs to take place.
Right.
And the employee is required to get proper notice to attend a disciplinary hearing. They need to be informed of the charges that they're required to defend themselves against.
Right.
They have the right to be represented by a fellow employee or shop steward if there's one in the workplace. They have the right to state their case, call witnesses, cross-examine. And then a finding gets made on a balance of probabilities. Are you guilty, not guilty of the particular misconduct?
Sure.
And then the question arises, is dismissal appropriate? Now, dismissal's not always appropriate for first offense. The law and our courts have for a long time said that employers should follow a progressive and corrective approach when applying discipline to the workplace. Because the aim of discipline is not to punish people or to dismiss them, but it's to correct behavior.
Yeah.
And it's only through a gradual application of warnings that we are able to try and rectify the behavior of an employee.
I see.
But we also have to understand that certain incidents of misconduct or certain categories of misconduct are so severe that it renders the employment relationship intolerable,
Sure.
even despite being a first offense. And in those instances, you look at assault, sexual harassment, theft, sabotage. All those kind of things are not something where you're going to say to somebody, all right, you've stolen 10 million rand from me. I'm going to give you a final written warning.
Yeah.
Don't do it again.
Yeah.
So the only thing the person knows is, okay, I should either stop, or next time let me try and get a little bit more before I get caught and get fired. So there are certain, and that's a misconception that often exists amongst employees, is that, you know, I've been here for a long time, I have a clean disciplinary record, I'm a good performer, but they forget that the misconduct in which they've engaged is so severe that it warrants a dismissal despite being a first offense. When we start talking about the capacity issue as a ground for dismissal, that's normally where you start talking about poor work performance or ill health. And there's a bigger obligation on employers there to try and assist an employee to either improve performance or to afford them an opportunity to recover from the illness that they're suffering. So the process is different to that where you have charges leveled against you, someone's found guilty or not guilty. It's an assessment about somebody's suitability to continue in their particular position.
I see. And in terms of how long this takes, and even from notice periods, you know, to, for example, in the case of misconduct and even capacity, how long a process like this can take. What are employees and employers looking at here in terms of notice periods, but also the periods of hearings in the case of dismissal?
Okay, so if we look at misconduct specifically, the law requires us, when you want to go into a disciplinary process, to give an employee sufficient time to prepare. Now, the law's silent on what is regarded as sufficient time.
Wow, okay.
But our courts have gone through a process and they've identified that you at least have to give a person 48 hours before he attends the disciplinary inquiry, just to give him more or less sufficient time to prepare. It obviously varies depending on every organization, because some organizations have disciplinary codes and procedures in place that would allow for 72 hours or 96 hours time to prepare for a disciplinary hearing, in which case you have to adhere to that internal process that exists. Normally when we get to a situation where dismissal is imposed as a sanction, the employees are ordinarily, for misconduct, dismissed with immediate effect. So there's no question about you dismissed with notice or that you get paid your notice in lieu of not working it. The only time that we really have dismissal with notice is in cases of ill health incapacity, or where the dismissal is based on the operational requirements of the business. Right.
And in terms of just, you know, people who may be feeling as though something unfair has happened in a process, either we're dealing with dismissal or dealing with capacity issues, what kind of rights do employees have, say, once that process has concluded, but they still feel aggrieved? What's the next step from there?
All right. The next step would normally be to ascertain whether or not the company's internal policies and processes allow for an appeal process. Now, an appeal against a decision to dismiss is not a right that an employee has. So some organizations have an internal appeal process, which the employee would then be required to follow or try and exhaust that measure in order to try and get the decision overturned. In an instance where there is no such internal appeal process, an employee retains the right to refer his or her dispute to the appropriate dispute resolution forum. Most of us know the CCMA. But certain industries like the motor industry, the metal engineering industry, they have a different dispute resolution forum known as the DRC. So you have to refer your dispute to that particular forum within 30 days from the date that you have been dismissed, in order then to have that forum review the decision that's been taken.
I see. Okay. Very interesting stuff here. A number of you are wanting to call in to speak about this. If you're an employee or an employer and you have a story about unfair dismissal, or you just want some advice or to get a better handle on the law, please give us a call. Joburg, 011-883-0702. And in Cape Town, 446 0567. We have a call coming through right now, actually, and that's Joe. Joe, how are you?
I'm all right, yourself?
Very well, thanks. What's on your mind?
Look, it's just a quick one, Susan. On the 17th of May this year, all right, I was dismissed because of conduct, all right. What happened is I was informed, everything was done accordingly, but the only problem is the last issue was when on the 17th of May at CCMA, we were called with the commissioner of CCMA, whereby a commissioner asked the representative of the employer if that would amount to dismissal. Unfortunately, at that time, I didn't have the contract with me, which I got from the employer. So the representative said yes. But after about 5 months, I found my documents, and only to find that is not there. Now, I want to find out what can I do after that, because I agreed with the CMA that the case can be closed, that I am guilty. But now, what the people from the employer side said does not. It's not the same thing as what is in my contract, where they said that yes, I should be fired.
Okay.
So that's what I want to find out.
Okay, thanks, Joe.
Yeah, I think it really depends. I'm not quite sure what the reason was for the termination in this particular instance. But at the CCMA, a commissioner will always, before arbitrating the dispute and determining whether or not a dismissal was fair or procedurally or substantively unfair, would normally engage the parties in a conciliation process to try and resolve the matter. And in some instances, employees might elect to withdraw their dispute from the CCMA. And where there was a physical withdrawal of the dispute, it does become a little bit problematic for an employee to later on try and reinstate that dispute. If there was no settlement agreement signed, or there was no written notice of withdrawal signed by the applicant or the employee in this matter, you would still have the right to refer the matter to arbitration if that process, for example, was just conciliation. Because once we've had a process of conciliation where parties try and resolve the dispute and you're unable to resolve it amicably, an employee still retains the right within 90 days from that date to request that the matter be set down for actual arbitration.
Okay. Hope that helps, Joe. Hope you have some options open to you still. We also have Shane, who would like to tell us a story about his experience with unfair dismissal. Shane, welcome to the show.
Hello, how are you?
Fine, thanks, Shane. What's on your mind?
Fine. Yeah, listen, we were in 3 trains, the two of us, me and the other guy. And then during the consultation time, the company employed another 2 people, of which we were never offered those opportunity to be entered into those positions.
Okay.
So I want to know if I couldn't
is that
know, is it okay?
Okay.
Yeah, there's obviously recourse there available to the person as well to refer a dispute to the CCMA. Okay. One of the things that parties need to consult on during the consultation process, especially when it comes to operational requirements, maybe I should first mention this, is that those kind of dismissals are what we deem to be no-fault dismissals. Because it's not that the employee has done anything wrong or that the company has necessarily done something wrong, but it's normally because of circumstances not within the control that now the company needs to downsize its workforce. Sure. So if vacancies do become available again in the near future, there is an obligation on employers to consider those that were previously retrenched for that particular vacancy, provided that they have the necessary skills or qualifications to fulfill that position. Because you might still have employers that go into a process where we've retrenched people in the sales department or in the administrative department, and now I've subsequently had a resignation in my engineering department. The employer is not prohibited from still filling that particular vacancy in the engineering department. However, where vacancies in the sales or admin arise, there is that obligation to consider those that were previously retrenched.
Okay, so they may, it looks on the face of it like there's some opportunity for recourse there for Shane.
Correct, yeah.
Thanks a lot. Lots of your calls coming in. We've got Nokolo, who would also like to share her experiences. Nokolo, welcome.
Good morning. How are you?
Very well, thanks. And you?
Very well, thank you. I just want to find out from you. I was laid off last year. I've been sick in and out of hospital and everything. So the management called me in and told me that I was not, I was not being productive because I'm always at hospital. And then I was told that I can resign on medical condition and everything else. And then after resigning, when I went to CCMA, under my name is written resigned, which makes it very difficult to get my UIF. Now I've been in and out of my work and UIF, and I still cannot be helped. What's the way forward, please?
Yeah, that is a very unfortunate situation. It's not uncommon for employers and employees to engage in these kind of discussions where there is a problem that exists. So, be it from an absenteeism point of view or even an incident of assault that has occurred, where a company engages the employee and says, "Listen, we have grounds, given your extensive absenteeism or your absenteeism on a regular basis, to now institute processes against you in order to dismiss you either for misuse and abuse of sick leave or to go the ill health incapacity route and terminate your services on that basis."
Right.
However, the alternative is you opt to resign. And in the event when an employee effectively resigns, the employer did not terminate. The employer mainly presented an option and the employee made an election of that option. So the company is entirely correct if they went ahead and they processed the termination as a resignation, because at the listener's own accord she had resigned. And that does affect somebody's ability now to claim UIF, because UIF you can only claim in the event where your service is terminated. You're not entitled to those benefits in the event of resignation or absconsion.
So employees listening who sort of are fearful about potential action or potential unfair action should make sure not to be sort of coaxed into resigning when your rights are different after you've done that.
Correct.
Yeah.
And parties can reach an amicable resolution to that when they have those kind of discussions. So instead of saying that the person has resigned, is to reach an agreement that we'll still go through a process, or you acknowledge your wrongdoing and you acknowledge that dismissal is appropriate, but this is the basis on which we'll terminate, and the employee could still be eligible for the UIF benefits.
Sure. We're talking unfair dismissal. Do you have a story of unfair dismissal? Are you an employer or an employee who would like some advice on this question of dismissal and how it works? We are currently in discussion with Tertius Wessels, who's legal director at Strata-G. That's Strata-G. And your calls are coming in. Various people wanting to share opinions and get advice. And right now we're going to go to Peter. Peter, welcome.
Good morning, gents. Thanks for taking my call.
Morning.
I'm an employer and I seek advice. We're a small entity. We're a professional services company. My question is, what are the grounds for dismissal? We do a lot of responses to client requests, and if an employee misses a submission, which has monetary implications, can they be dismissed immediately? Because even though we haven't won the business, it's an opportunity cost, and sometimes these can run into millions of rands. What recourse do I have as an employer when this happens?
Thanks, Peter.
Right. Peter, I think one of the important things to note is that where an employee there's a certain level of expectation or certain task or duty that an employee is required to perform, and they fail to execute it in the manner that is expected of them, an employer does have grounds to take disciplinary action against them. And obviously, whether or not there's actual damages or potential damages becomes irrelevant to a certain extent, but obviously in instances where there's actual damages, the severity of the misconduct becomes a lot more severe and could potentially justify dismissal. However, the whole thing about dismissing somebody with immediate effect is often taken out of context. That dismissal with immediate effect can only be imposed once you've followed a fair process. So once you've gone through a process of having a disciplinary inquiry, giving the person an opportunity to state their side of the case, present evidence, call witnesses, etc., only then can that sanction be imposed.
And when does the question of suspension come into it? Is one able to suspend an employee pending a hearing? How does suspension fit into this question of dismissal?
All right. So there's two types of suspension that we normally get. The one is a punitive suspension, and the one is a precautionary suspension. So precautionary suspension is often utilized to avoid any interference with the disciplinary process. So when an employer anticipates taking disciplinary action against an employee for very serious misconduct, and the employer has reasonable grounds to believe that the employee's continuous presence at the workplace will be detrimental to the disciplinary process, the employer can suspend the employee pending finalization of the disciplinary proceedings. Now, there's various reasons why you would not want the person to be at work. You might fear that they intimidate witnesses, tamper with evidence, etc. But you cannot simply suspend the employee without pay. That suspension has to be with full pay and benefits. And the employee must also be afforded an opportunity to present reasons as to why he or she should not be suspended before a final decision gets made. So we normally inform an employee or advise clients to inform an employee, listen, there's these allegations against you. We're looking at, or we're intending to suspend you for the following reasons, and afford the employee an opportunity to say why not. Because we have to understand that once you get suspended, whether or not you're guilty or not guilty gets determined at a later stage. That suspension has an impact on the employee and his reputation within the organization, which could influence job advancement, etc. So you have to afford an opportunity for somebody to say why they should not be suspended. Once you've considered those reasons, it remains the employer's prerogative then to either effect the suspension or not. The punitive suspension is normally where suspension is imposed as an alternative to dismissal. Where you say, you know what, you're on a final written warning. I could potentially be dismissing you for this misconduct. However, as an alternative, I'm suspending you for 2 weeks without pay. So that you can understand what the impact of this is going to be. Because come the end of the month, an employee only receives half their salary. Their ability to meet their financial obligations won't be there. And often employees then start realizing, wow, you know, I've only been without a job for 2 weeks, and look at the impact on me. I better get my act together to avoid these things from happening again. But the disciplinary code normally needs to make provision for punitive suspension as a sanction.
Interesting. So, you know, there are a number of options that employers would need to consider and employees would need to know about, and it's not as easy as just, you know, the sort of series/Hollywood dismissed without, you know, dismissed and forevermore, basically.
I think a lot of employers often wish that it was American law and you could just say you're fired. But the reality is that it's not like that. And for every organization and industry that you're working in, things are different. Rules are different. You know, there's a difference between somebody's domestic worker coming to report for duty whilst under the influence of alcohol and somebody that is a crane operator or driving trucks reporting for duty under the influence. The nature and severity given their positions, their tasks are very different, and things are treated differently. So employers must make sure that they get proper advice and assistance to make sure that their rules and policies and procedures cater for their environment, because everybody's roles are so different.
Okay, excellent. We're going to take one more of your calls before we head to some headlines, but we want to go to Sunny Boy, who would like to share an experience of dismissal himself. Sunny Boy, welcome to the show.
Thank you for taking my call.
Sure.
Yeah, look, I was dismissed in 2012 for merely attending a training at CCMA for 3 days. Yeah, prior to the attendance, we did send the employer a notice that we'll be attending. I was not myself there. We were 4 of us, if I'm not mistaken. And out of 4, they decided to dismiss me alone. So that was in 2012. Now, my case has been pending since then in the labor court. Now, I just wanted to ask, and then what can I do to pursue my case without involving the union? Because in any case, I'm no longer with them. That is the first question that I have, and I've got the second question.
Okay.
Now, my second question will be, now, since an employee who's contacted to a client, now, can the client itself dismiss me on my misconduct on the basis that I'm employed by my employer or not them? I don't know if I did put it correctly.
Yep, no, sure. Thanks, Sunny Boy. We appreciate that. Listen, Sunny Boy, please stay on the line. We're going to go to headlines. We've got Aurélie Kalinga standing by, and when we come back, we're going to attend to your 2 questions.
702 at Cape Talk. World of Work.
It's 25 minutes to 12, and we're talking about dismissal and unfair dismissal. We're taking calls from people who've had experiences, people who want some legal advice on the whole question of dismissal. And just before we went to headlines, we had Sunny Boy, who called in with an experience that he wanted some advice on. Maybe we can just get to his question first. Tertius?
Sure. So my understanding is that the dismissal occurred as far back as 2012, and that the matter is now currently still with the Labour Court. And that's one of the unfortunate realities that does exist for employees.
Okay.
So once a matter has gone through a process of arbitration at the CCMA, the CCMA would normally give an award that indicates was the dismissal fair or was the dismissal unfair.
Right.
If the CCMA determines the dismissal was fair, then that's the end of the matter.
Yeah.
It's only in the event where they determine that it was unfair for either not a fair reason or fair process, that the employee would be awarded some form of relief.
Okay.
Now, it's either party's prerogative that if they're unhappy or they're not in agreement with that particular award, to take it on review to the Labour Court. And that becomes a whole legal and judicial process, unlike the CCMA, which is aimed at speedy recovery or resolutions of matters. And those matters can drag on for 2 years, if not longer. Now, my understanding from Sunny Boy is that he was previously assisted by a trade union. He's no longer involved there. The only thing that I would advise there is to maybe seek legal representation so that somebody can at least ascertain where are we with this particular matter, so that they can step in as attorneys on record, be it on a pro bono basis, and try and push the matter forward in order to bring it to resolution.
Okay. Thanks for that. Hope that clarifies it, Sunny Boy. And we're going to continue to take your calls. We've actually got a lot of them coming in now. And we're going to go to Rasta, who would also like to share some experiences, get some advice. Welcome.
Hi, my brothers.
Sure.
My question is, how long can an employee wait for a hearing letter after being dismissed? Or can an employee call the employer to send somebody to come and fetch that letter?
Okay.
For hearing. Yes, thanks.
Thanks.
All right. So, if I understand the question correctly, it's more about a matter of a hearing letter.
Yes.
Is it being me sitting at home waiting for the letter, knowing when I am going to go back in order to go through the hearing, or is it the letter that the employer needs to give after the fact that the hearing has happened? Now, if a person has been suspended pending the finalization of a disciplinary hearing, but at some point in time you are not receiving your notice to attend the disciplinary hearing, it is incumbent upon the employee to raise that with the employer and say, listen, the suspension is now becoming unreasonable. Either you start issuing with a notice to attend or give me reasons as to why it's not, or the employee can then simply refer an unfair labor practice dispute to the CCMA and start challenging the validity of the suspension based on the fact that it's become unreasonable.
Okay. And how long do you think that sort of unreasonable timeline might be for a letter?
So it depends. So it depends on whether or not there's a long ongoing investigation into the investigations, but normally the disciplinary codes of the employers will dictate that the suspension may not exceed a certain time frame, be it 30 days or 60 days.
Yeah. Okay, Rasta. So we're not sure exactly how long that's been, but if it has been something that you've been waiting on, or if someone has informed you and you still haven't got a letter, then it is incumbent on you, and Tertius would suggest taking it up. Many calls also coming in. We've got Rumiel. Welcome.
Hi there.
Hi.
Okay, so I have a few questions. You've kind of answered it already with the other callers, but I find myself extremely frustrated about my situation.
Sure.
I was a victim of bullying and harassment in my workplace. I lay a grievance against my manager, which led to a hearing for her. And shortly after the hearing, I was put into performance management. It went on and eventually led to me being dismissed for incapacity, poor performance. I took the case to the CCMA. The CCMA case dragged on for almost a year. I felt like I didn't get enough support from the commissioner, and he did not listen to my case in as far as the fact that I was a victim of bullying. I laid a grievance, which led to me being put into poor performance management. I feel aggrieved still, because the CCMA found in favor of my employer. What would have been the best way for me to deal with it after the CCMA's finding?
Okay, thanks very much for that.
Okay, so the best way to deal with a matter like this where you're unhappy with the CCMA's outcome is, like I've explained, your only recourse is really to take the matter up for review to the Labour Court and to say that the Commissioner committed a gross irregularity by not considering certain facts or disregarding or misapplying his mind to the matter. But that, again, is a process that's going to take 2 years to get finalized. But that's the only recourse that one has when you sit with an outcome where you are aggrieved with. And the reality is there's going to be a so-called winner and so-called loser at the end of an arbitration process. In this particular instance, it sounds like there was some unhappiness within the workplace or with a particular manager. The company dealt with it internally as they deemed fit. And for all intents and purposes, those issues pertaining to the bullying or the victimization was then effectively addressed and resolved. So the Commissioner would have purely focused on the performance issue and looked at whether or not there was proper training, assistance, guidance given to the employee, whether or not there was sufficient time afforded to improve. And if the company was able to illustrate it, the Commissioner would determine that dismissal would be fair.
Okay, Rumiel, so that's what's available to you. And I suppose, just before we go on to Oluetu, the accessibility of actually finding legal representation, I suppose, does become a bit difficult for employees who feel aggrieved past the CCMA point.
That is so. And, not everybody has readily access to legal representation, and legal representation can be very costly. But there are institutions that do assist employees with their disputes. You get a lot of pro bono officers that would take on an employee's matter where they assess, listen, do you have grounds? Do you not have grounds?
Sure.
I'm not even sure if the Wits law clinics and those kind of legal clinics do also sometimes offer their assistance in helping employees deal with these issues, because going to the CCMA is one thing. It's more of an informal process, and whilst people are still required to present evidence to prove their respective matters, it's not like a court of law. And that's one of the reasons why legal representation is also not automatically allowed in the CCMA. But as soon as you start going to a court of law, there are certain rules, there are certain prescriptions that do apply. And unless you have somebody that is supporting you through those processes, that know and understand what they are doing, you are going to end up feeling frustrated.
Yeah, sure. So if any of you are going through financial hardship and wanting to pursue further means, do look for the pro bono offerings that are out there. Oluetu, welcome.
Hi, thank you for taking my call.
Sure thing.
I'd like to find out if someone signed a permanent contract but had a 6-month probation, and throughout the 6 months I have been receiving positive feedback, and then 2 days after the 6 months they're dismissed with immediate effect. Is that a fair dismissal?
Thanks, Oluetu.
So once again, the issue behind probation is also widely misunderstood between employees and employers. So probation period is not your license to fire an employee. It doesn't mean somebody is employed for a certain period of time. Come the end of that period, you then decide, okay, I still want you, I don't want you. At any point in time, if you want to terminate somebody's services, you need to illustrate that you had a fair reason and that you followed a fair process.
Even with these so-called probation contracts.
100%. You have to still follow a fair process. So if I've been receiving good feedback throughout my probationary period and saying I'm doing well, I'm meeting the company's performance standards, and one day I just get called in and I get told you're dismissed, then there's definitely grounds to claim for an unfair dismissal, because you're not sure of what the reason for the dismissal is, because it can't be performance if you've been told you're a good performer. And it doesn't sound like there's any process that's been followed.
Okay, we're talking about dismissal. We're talking about dismissal from the perspective of people who feel that they've been unfairly dismissed, but also from the perspective of employers who may feel that there's been misconduct or that there has been a change in the capacity of their employees. We are taking your calls as well. I see some calls coming in. We're going to go for a quick break, and after that we're going to come back and keep taking your calls and hopefully sharing some advice with you as we discuss this question of dismissal. Stay tuned.
702 at Cape Talk. World of Work.
We're approaching 10 minutes to 12, and we're talking about dismissal. We're talking about dismissal from the perspective of those who feel they've been unfairly dismissed, and also employers who feel there's been misconduct or a change in capacity on behalf of one of their workers. And we're joined by Tertius Wessels, who's legal director at Strata-G. That's Strata-G. And we're taking your calls. We're going to go to Matthew now, who has a specific case he wants to ask about. Matthew, welcome. Matthew, are you with us?
Yeah, I'm with you. It's an interesting talk. I've just got an interesting question. What is the position with, I believe the fixed-term contracts are no longer applicable, and I wondered how that would affect a pastor who's called to a church for a period of, say, 5 years.
Okay.
Does that mean at the end of 5 years his term cannot be ended? And if so, what is the procedure if the relationship between him and his congregation is no longer workable? I'll listen on the line. Thank you.
Thanks a lot.
So I think the one misconception that we need to clarify is the fact that fixed-term contracts are no longer valid.
Okay.
That's definitely not the case. We did in the past see a lot of abuse of fixed-term contracts of employment, where employers would employ people for random periods of time with the purpose of just assessing, do we want them, do we want to keep this person on, yes or no.
Right.
And in 2015 we saw changes being brought about to the Labour Relations Act, and the law now specifically governs fixed-term contracts of employment, and it says that those contracts are valid and they may be used, provided that the reason why you're using or you're employing somebody for a fixed-term period is for a valid temporary reason. And the law gives us various grounds for that. So it's saying somebody is replacing somebody that's on maternity leave, or I've got a specific project or task for which I require you, and that's only going to be for a year or 2 years. So fixed term contracts may still be used at the end of the day. However, in situations like this, and I think it's often the situations that you also face with directors in a company, where the relationship becomes becomes intolerable, or for some or other reason parties no longer see it fit to continue working with one another, whilst you wouldn't necessarily, depending on what those reasons are, you won't necessarily have to go into a whole disciplinary hearing process. Parties must be afforded an opportunity to state their side of the case before a decision is ultimately made.
Right.
And I think that's the key principle for any process, is listen to the other side. Hear what the other person has to say before you make the decision or make a final decision at the end of the day.
Right. Yeah, that does seem to be the key theme here with the various processes. We've got some SMSs, Tertius, as well. Let's try and get to some of those. Someone says, if a disciplinary hearing can be done, then immediately after a verdict is rendered and a dismissal is administered, does the law require a timeline for the employee's representations to be considered?
All right. So once an employee is normally found guilty or not guilty of a particular misconduct, both the employer and the employee should be afforded the opportunity to make submissions in mitigation and aggravation of the sanction.
Okay.
So once I've determined, where you're guilty of this particular misconduct, I now have to consider, you give me factors as to why you should not be dismissed, and employer, you give me reasons as to why you believe I should be dismissed.
I see.
And one then at least has to apply your mind to those factors. Now, sometimes when you're dealing with an issue like dishonesty or theft, I mean, the outcome is almost a guarantee that it's going to be dismissal.
Sure.
So there's a lot of factors to consider, but you at least have to apply your mind to those factors before you then communicate the decision to the employee.
I see. Okay. That was an anonymous SMS. We've got another one coming through here. We have, can one revive a case which was concluded in 2005? This is someone who went all the way to the labor court, and they still felt that despite even approaching the labor court, they wanted to appeal. Their advocate didn't agree. Is there even further recourse, even if you feel the labor court hasn't really taken the decision seriously?
Look, there's always recourse available to employees, but the reality is, or to employers, if you're unhappy with the CCMA's decision, let me approach the labor court. If I feel there's grounds to appeal against the labor court, let me go to the labor appeal court, let me go to the Supreme Court of Appeal.
Right.
And if there's a constitutional issue, let's go to constitutional court. But the reality is there's certain time frames that need to be adhered to in order for you to follow these processes. And if a person has missed that time frame, or you haven't taken the necessary action within that time frame, you're going to have pretty good reasons to explain to a court of law, why have you done nothing for the past 13 years to refer or pursue this matter? And unless you can say, well, I've been in a coma for the past 12, you're not really going to convince somebody that you're serious about pursuing the matter.
Sure.
You are the instigator of the process, and you must take charge of that process.
Okay, we've got Noziziviwe, is that right?
Nozizwe.
Oh, we've got Nozizwe. Welcome.
Thank you. Yes, can you hear me?
We can hear you, Nozizwe. What's on your mind?
Yes. No, it's just a question. I was entered on duty, and I've been away from work since February 2017 because I've been going through hospitals. I've had 2 spinal operations plus other minor procedures. So that took me away from work. Whenever I thought I was going to recover, then the pain reoccurred, and then I had to stay on and on and on. So now comes the new president after Nazareth, and then it gets a reshuffle, and then we get a new minister on board who comes with a new acting DG. Then when the new acting DG sees me, I've been at home since February 2017, without asking any questions, she goes and terminates me. At short notice, she writes me a letter on the 30th of July to say on the 31st of July, I will exit the department. And indeed, he exited me. So I warned her that this is going to put all my finances in jeopardy. And indeed, it has. And this was even before I could even get my pension payout and other benefits such as medical aid, because I've still been consulting with my doctors. So now, the fact of the matter is that I had applied for ill health retirement because there are a number of forms that had been sent to me whilst I was still on sick leave, even some of them sent in whilst I'm in hospital, and filling them in, not knowing that it will end up like this. So I've really been troubled by the way it's been handled. So here I'm just questioning the procedure at which I was terminated.
Okay, thanks.
Yeah.
Thanks, Mam Nozizwe. We've got that story, Tertius. Any advice you can offer there?
Yeah, look, it doesn't sound like a due process has been followed. The reality is that often employees do sustain injuries on duties, and there is a certain obligation on employers to report that matter and see the matter through. But it's also incumbent upon employees to make sure that they go for the regular assessments and that a final resumption report is ultimately obtained to say, is this employee going to be able to come back to work? Are they not going to come back to work? Has the injury or the injury that the employee has sustained resulted in that person now being permanently incapacitated and no longer fit to perform the duties for which they've been employed? So if that is the reality that exists, it obviously does give an employer grounds to terminate, because I cannot expect to retain somebody in a position where that person is no longer fit to hold that position. And if there's no suitable alternatives, then I'm left with no other option but to terminate. But like I said initially, there's always a due process that needs to be followed. And in this instance, just to receive a letter doesn't quite sound like due process was followed.
Yeah. Hope that helps, Nozizwe. And then you mentioned something earlier that I wanted to also chat to you about, which is, there are different contexts here and different forms of employment. And where employees are more vulnerable, perhaps even in fields of work where sometimes employment contracts aren't even present. And you mentioned the case of domestic work, for example. Is recourse the same? And what are some of the dimensions of dismissal, given sometimes a lack of contractually binding situation?
Yeah, so there's this misconception that unless there's a contract of employment, you are not actually employed by somebody. But that's actually the opposite is true. So unless you have a contract of employment that specifically stipulates that you are a temporary employee or that you're employed for a fixed term period of time, as soon as I start working for you and I start working for you in excess of 24 hours a month, then it can be regarded that you are permanently employed, be it that a written contract of employment exists or not. And the law still applies to that employer-employee relationship.
Sure.
And no matter what contract you have, or even in the absence of a contract, the law applies. I cannot contract outside of the law. So I cannot, for example, say to somebody, by law you're entitled to 15 working days annual leave per year. I'll pay you 5,000 Rand extra a month, but then you only take 5 days leave. It doesn't work that way. There are certain basic conditions and requirements that exist in law, and irrespective of the contract, if it's less favorable, the law will supersede and will always apply. It is just incumbent upon people that find themselves in situations where, I don't have a contract of employment, or I'm not getting pay slips, or whatever the case may be, to rather address that with the employer or report the matter. We have seen the Department of Labour going on this drive to ensure compliance, and they've been visiting a massive amount of businesses in order to ensure compliance. And that is by ensuring our contracts are in place, are people receiving their pay slips, employment equity plans. So the Department of Labour is really aware that certain people, vulnerable employees, are being exploited, and they are pushing to try and get compliance right.
Absolutely. That's been Tertius Wessels, who's legal director at Labour at Strata-G. That's Strata-G.
Experience the drive for tomorrow with cutting-edge design and technology when you purchase a new Audi A4 or A5 with Audi Connect. Choose between a no deposit offer, low repayments, a guaranteed buyback, or a 90-day deferred first payment. Visit Audi.coza for more or contact your Audi dealer for a test drive. Offer subject to approval from Audi Financial Services, a division of Volkswagen Financial Services, an authorized FS and registered CP. Audi. Vorsprung durch Technik.